And for this, I want to get right to Valerie Bogart, one of the leading experts in New York State and the country. She's the director of the Evelyn Frank Legal Resources Program of the New York Legal Assistance Group. She is the leading expert on New York Medicaid, an advocate for access to long-term care for low-income seniors and people with disabilities. She's an attorney that all attorneys learn from. And with that, I give you Valerie Bogart.
Thank you. Just trying to start at my PowerPoint here. Why isn't it showing up in the shared screen? Let me just figure that out. It should be. Okay, can you see the PowerPoint? Can you see the PowerPoint? Hello? Hello, can you see that? Okay, all right. Okay, thank you. And thanks to the Piero Law Firm for inviting me today. And thanks to so many people who have such strong feelings about long-term care services and access. So I'm from NILAG, the New York Legal Assistance Group. We're a New York City legal services nonprofit, and my own unit specializes in Medicaid for older people. So I'm not covering everything on this agenda. Some of this is here for your reference later. We're going to focus on two things. One, some good news from this year's budget of Medicaid expansion. And two, one of the changes that Lou just referenced that started this week, the Independent Assessor for Home Care, which has started not so well this week. But I do urge you, if you do home care, to look at some of the other materials on the slide. So the good news, we talked about some compromises made in the budget. You heard about home care wages, which was a compromise from the Fair Pay for Home Care, which we hoped would pass, and it didn't. But what did pass was an expansion of Medicaid income and asset levels, and big thanks to the governor and to the state Senate and Assembly for jumping on this. I was part of a coalition that proposed this, and it comes from the inequity that has developed since the Affordable Care Act was passed in 2014. Income limits went up, but only for people under 65 and even under 65 who don't have Medicare. So they went up to 138% of the federal poverty line. And that's still low, but it's not as low as what it is for people over 65, where it's only 85% of the federal poverty line. And that's what it's been for years and years and years. Plus, there's no asset limit for people under 65, and we call that MAGI Medicaid, because the Affordable Care Act uses tax rules, adjusted gross income, so they call it MAGI. And the non-MAGI group, which are the age, blind, and disabled, have a strict asset test. So what happened, the legislature embraced the governor's proposal, which we have proposed, to make the income limits the same for all age groups, 38% of the poverty line, and also bring the QIMBY Medicare Savings Program up to that line. It was only 100% of poverty. And the QI1 level, which is the Medicare Savings Program that subsidizes the Part B premium for higher income people, goes all the way up to 186% of the poverty line. And this was so crucial because the Part B premium is now $170.10 a month. So think of somebody with income of $1,700 a month. That's 10% of their income just to pay that premium. So now that will be covered for everyone. up to those income levels. These increases start in January. And this chart, which I think you can all download, is a nice thing for your wall. You can see how much these increases will go up. Now, of course, next year there's a new poverty figure, so they should go up even a little more. But, and the asset test is going up about 50%. Now, I've gotten a lot of questions about this. Will there still be pool trusts? And I know we'll have the speaker today about pool trusts. Yes, you can still use pool trusts. You can still use spousal refusal. You can still use spousal impoverishment budgeting. And there's still spend down. And why is that? Because it's still the same Medicaid program. The only thing that's changed is there's a higher income limit. So when you calculate how much you need to put in the pool trust, that will go down significantly, which is great news. And for some people, it will be eliminated. They'll no longer need to use pool trusts. And my salute to NYSARC, who had signed on to this proposal as a coalition when we launched the coalition, even though they said, we know we'll lose some members, but this is the right thing to do. And we thank you for that. So nursing home budgeting doesn't change. If you're permanent placement, you still have to spend all your money on the nursing home care except for the $50. So that doesn't change. Now, there was some disappointment by our coalition. We had sought to repeal the asset test for non-Magi Medicaid. And what was really disappointing is that the governor agreed and proposed that in the budget, and the Senate and the Assembly put it in their budget bills. So still in the last moments of negotiation, that fell out of the budget, and instead we got these small increases. Now, why was this so important, and why do we still hope that the asset test will be repealed? Is that the asset test is baked in with racial bias. So think about someone who doesn't own their home. They're a tenant. Their life savings is $50,000. Can they get Medicaid now? No. They have to spend down their assets to, now it's 16,000, next year it'll be about 28,000. But that same person, if their savings was in a home, if they can get a home with equity of $955,000, or if they had an IRA, that could be $1 million IRA, and they could be eligible for Medicaid. Now, statistically, and if you look at our letters, who is more likely to own homes and IRAs? White people. Statistically, people of color, for many reasons we've all read about, and there's citations in here, from redlining to lots of different reasons, tend to have their savings in the bank and not in these protected assets. So it perpetuates these racial biases in healthcare to keep the asset test. But we made a step, and we do appreciate the governor and the legislature for doing that. This will go into effect next year, provided that it's approved by the governor. And the good news is that because there has been a moratorium on any cuts in Medicaid during the pandemic, it's called the maintenance of effort requirements of the public health emergency. So no one spend down could have gone up, and no one could be cut off Medicaid because of these protections. So now we think the public health emergency will be extended through the end of the year, so that when everyone goes through their renewals and is rebudgeted, they'll be rebudgeted under these new income limits and the new asset limit. That's not 100%. The timing we still hope will work out. But if that's true, then people can recalculate how much they put in their pooled trust for next year and even consider closing their trust. And of course, for new applicants, that will make a huge difference. So now let's go to the main topic of today, which is one of the Medicaid redesign team changes that Lou mentioned were enacted in 2020. So in the height of the pandemic in April 2020, when there was no money, the money was not flowing then like it was this year, as we've heard about. And we had a governor who had quite a bit of clout, as you recall. And they pushed through these changes that the legislature really had no bargaining power for. So these went into the budget, and the independent assessor started Monday, and that's what I'll be talking about the rest of the time. What is not starting are two other changes that have been put on hold because of these protections that Congress enacted, saying Medicaid cannot be restricted during the pandemic. One of those is the limitation on who is eligible for personal care or CDPAP, saying for the first time that someone must need assistance with 3 ADLs. That's activities of daily living. And that's physical assistance with 3 ADLs to even be eligible for 1 hour of home care. The only exception they enacted is if someone has diagnosed dementia, and then they can qualify with 2 ADLs. Now, we're not going to have time to get to these, and it's not being implemented at least through this year because of this the public health emergency. But there's all sorts of problems. We think it's totally illegal. It discriminates against people with many diagnoses who need help, but might not fit those criteria. Then there's a 30-month look back for qualifying for people who are applying for Medicaid to get MLTC services or home care or assisted living program. Not covering that either today. It's on hold. The earliest, when this PowerPoint was done a few days ago, we thought the earliest that these two things could start was October 1st. But as of just 2 days ago, I now believe the earliest they can start is January 1st. And that's because it's been publicly reported that the Biden administration is likely to extend the public health emergency at least one more time, because they didn't give 60-day notice that they promised they would give. That would have to the states that it was ending. That notice would have had to be given May 15th. It wasn't given. So therefore, everyone is inferring at least one more extension, which would bring us to the 1st of next year. Also, the state hasn't gotten a lot of approvals for these, that it needs to put these into effect. I think they've just sort of put them on the back burner while they go ahead with this independent assessor. So if you're someone who likes to look at, not just hear me, but look at the guidance, it's all at the link on the website, the state's website, and there's very specific guidance that's been issued very recently. So you look at these dates and you think, my goodness, this was issued only April 28th and they're already implementing it? Well, yes, that's a big question. And from the calls we've been getting this week, we're seeing the fallout of implementing something with so little lead time, that there just aren't procedures and infrastructure to prepared for such a massive change. The state's website on this has a section for consumer information and FAQs, but nothing is posted. And it went live Monday. You might hear in my voice, I'm a little angry about this because people will be hurt. So this is what it is. The New York Independent Assessor, it's replacing conflict-free evaluation. So it's basically a new name for the conflict-free assessment in part, all right? So just a few acronyms here because this program is loaded with new acronyms. So now they're calling the conflict-free assessor NIA, New York Independent Assessor. And when that nurse comes out to do the nurse assessment, they're calling it a CHA, the Community Health Assessment, or an independent assessment. So if you call to request this assessment, they might say your CHA is being scheduled. That's the nurse. But they're still using the same assessment tool, that UAS. But it's now going to be two parts. The nurse does an assessment, but in this new regime, also, there's something called an independent practitioner panel. And that panel is made up of either a doctor, a nurse practitioner, a physician assistant, and they'll schedule an actual appointment to examine the client. They call it a CA. So you might be hearing that acronym. And after that appointment, if they approve, they are the ones that approve enrollment into MLTC or the request for personal care or CDPAP. They don't decide how much the client gets. They just decide yes or no, are they eligible? And if they are eligible, that practitioner's panel prepares an order. So that replaces what we call the M11Q in New York City, or the statewide form, the DOH 4359 physician's order. So that is called the PO. So that's a whole new thing. So when you ask for a conflict-free assessment now, you're not just getting one assessment, you're getting two, because, and it won't be at the same time, they'll schedule them, they're supposed to schedule them within 14 days. Then there's a new thing called the Independent Review Panel, which I'll talk about later, all right? The PowerPoint uses a bunch of other acronyms that I think you know, and we're gonna really run through this. So the other thing that's so new is I've mentioned that this is replacing the conflict-free assessment, okay? And that's true. It's replacing it and adding to it by adding this independent practitioner panel. But that's not all NIA, the New York Independent Assessor, does, all right? It takes over all nurse assessments that have ever been done for personal care or CDPAP. Not only that initial assessment for eligibility, but once it's phased in, and it's not all starting this week, I'll talk about what the phase-in is. This will take over all MLTC nurse assessments. So when that nurse does the reassessments, which will now be annually instead of every 6 months, when the client says, I need more hours, and they do a new assessment, it will now be done by NIA. When the client's coming out of rehab, that assessment will be done by NIA, and it will always be accompanied by this IPP, the Independent Practitioner Panel. Now, this is for all MLTC, Medicaid Advantage Plus, but not PACE. Now, that's not all right? So there are 3 different portals for people in New York State to get personal care. And it's not that you just have a choice of any one. Many people are mandated to go to MLTC because they're an adult with Medicare and Medicaid. And unless they're exempt, that they have to go to an MLTC plan. Those who are exempt or excluded from MLTC apply for personal care or CDPAP at their local district. So that's your County Department of Social Services. In New York City, it's HRA. And there are not that many people who are exempt, so a lot of us don't have a lot of experience with that, but there are people who are enrolled in home hospice. You can enroll in an MLTC plan if you're in home hospice. There are people in the OPWDD waiver, or the traumatic brain injury waiver, or the nursing home transition and diversion waiver. They can't, well, people in those waivers, some of them are excluded, some of them are exempt, but they have either the option or they must apply to their Department of Social Services for home care. All right. And then there are people like age 18 to 21 who can apply because they don't have to enroll in MLTC. So that's a second bucket. And NIA is taking over the nurse assessments for DSS. It used to be that HRA or Dutchess County DSS sent a nurse out to the client to assess them for home care. That's over. Maximus has the contract for this program, has hired all of those nurses, as I have heard, paying them big bonuses to come over, do these assessments all over the state. So that's two buckets. The third bucket, the third way people get personal care or CDPAP in this state is through what we call a mainstream managed care plan. And those plans, we just go right at the bottom of this slide, those are the plans that are mandatory for people who don't have Medicare or other primary insurance and who have no spend down. So these are mostly people who are on the ACA Medicaid or on Obamacare. They're mostly people under 65, but there are some people who are elderly or people who have disabilities who are in these plans, such as SSI recipients who can't get Medicare because of their immigration status. All right, now we have these clients. How do they get personal care or CDPAP? From these plans. So, and these are huge plans. You know, there's something like 6 million New Yorkers in these plans. So NIA will take over their home care assessments also. So in all of these situations, when someone asks for personal care or CDPAP, now the request will be transferred to NIA to send a nurse and to do this medical assessment. And then there's the high need review panel that they'll do for people over 12 hours a day that I'll talk about more later. Now, the most common misconception I've heard about this is like, well, how does NIA decide my hours? They do not decide hours, all right? They're doing the assessments. And for the nurse, it's the same assessment that the MLTC plans always did. It's the same UAS assessment. And that's been used for the last quite a few years now by DSS and mainstream plans too. The Independent Practitioner panel is doing their own new assessment, and I haven't seen their form. They haven't shared it. So once those assessments are done, the case bounces back to these three entities, whichever one the client is with, and it's those entities that decide how much home care the client gets. They use those assessments to make that decision. So what's the rollout schedule? It is what started this week on Monday. So people who were not getting personal care or CDPAP anywhere in New York State, that's what really started Monday. So who were those people? people seeking enrollment into an MLTC plan or a MAP plan. So in other words, people who would normally have been requesting a conflict-free assessment, now they're making the same call to the same number, but now they're requesting this NIA, this two-part assessment of a nurse and a doctor, okay? That started Monday. What also started Monday are those other two buckets, those other two portals into personal care for people newly requesting care. So if someone was first applying to your DSS for personal care or CDPAP, that started Monday, except only those applying using the standard time frame, not immediate need. Okay, not immediate need. Now, many of you are familiar with the immediate need procedure, which is a fast track procedure to get Medicaid and home care. That did not start Monday. It's people who are in home hospice, they're in the TBI waiver, they need personal care, they're applying, but not on the fast track. All right. What also started Monday are people in those mainstream managed care plans. Those are the ones under 65 or that don't have Medicare. If they're newly applying for personal care or CDPAP. So that's what started Monday. What will start in 2 months, July 1st, oh, it's just 6 weeks actually, are the immediate need applications and any requests to a mainstream plan made on an expedited basis. And on the footnote here on this article, you see the standard for when can you ask that a request be expedited? What is the standard? So if a request can be expedited, then you always want to ask for that, because otherwise it takes 14 days for a plan to process it, and subject to a 14-day extension, which they're allowed to take, so it's really 28 days. If you want it faster, really consider whether the standard for expediting is met. All right, so that's July 1st. So what does that leave out that is not starting yet? That is the annual reassessments and any request for an increase. So people in MLTC plans will not be using this system now. They need an increase, if they're getting discharged from rehab, if they want to move from plan to plan, that's not starting now. Okay, it's only brand new requests for people. All right. Now, there's some details in the guidance that they just issued in the last 2 weeks about, like, what if the request was made before May 16th for a conflict-free assessment or for immediate need or to the mainstream plan? What the guidance says is that that should be processed under the old rules, that the plan should just go ahead and process it, or the DSS should go ahead and process it. Well, I've already heard problems with this now. In fact, I heard someone report that the NIA rep, customer service rep, canceled the old assessment and said, okay, now we're going to do the new assessment. You know, I heard that. I don't know if it's true, but this is brand new. So I'm sure there's going to be a lot of kinks. This is the basic order of things. This slide tells you what number people call, which is to request this New York assessment, NIA, New York Independent Assessment, which is the same number that used to be used for conflict-free. It has expanded hours. You can see that on the slide, Monday through Saturday until 8 p.m. They are supposed to schedule these 2 assessments within 14 days. Which we'll see if that's the case. We know that there were already delays scheduling just the nurse assessment for conflict-free. So for if them to now be able to schedule both assessments in 14 days, I am really skeptical. So then NIA issues an outcome notice. And that's sort of as it's always been for MLTC. They always issued a notice saying, yep, you're eligible to enroll in MLTC. Go ahead and do it. But now they'll also issue it for people for DSS and people applying to mainstream plans. And that notice, if it's denied, will have fair hearing rights. Now, the new thing here is this goes back to, we'll talk about MLTC enrollment in a minute. Right now, I'm just talking about people apply to the LDSS or the mainstream plan. Goes
Valerie,
back to, yes.
got about 5 minutes.
Oh, okay. So it goes back, there's a lot more in the slides you'll look at on your own. The plan decides the hours. If they approve less than 12 hours a day, fine, you're good, you're done. But if they decide you need more than 12 hours, it gets referred to an independent review panel that decides if the plan of care proposed will maintain health and safety at home. And the wrinkle in MLTC is that it's the same two assessments. NIA still decides whether you are eligible. One big change is that initial determination of eligibility for MLTC is good for 1 year. It will no longer expire after 75 days. That's an important new takeaway. So in the plan, then you shop around to your plans. So what do you need to enroll in MLTC now? You need those first two assessments. You need the NIA outcome notice to say you're good, you're eligible for MLTC. And that's all you need. You can then enroll in the plan. Now, let's say the plan says, okay, we'll enroll you, but we aren't going to recommend live-in 24-hour care. You can still enroll, but before the plan is required to refer that case to the independent review panel. They can make the referral while you sign the enrollment form, and you can enroll. It doesn't have to be completed before you enroll. That's under their policy, okay? So you shouldn't be told, we first have to do this and get it approved before you can enroll. That's not true. How does a consumer let all these assessors know, these are my diagnoses, these are my prescriptions, this is what I need? We don't know. There is no procedure for the consumer to submit anything. They're supposed to just have their prescriptions ready for the nurse when they assess. If it's by telehealth, how do you even show them your meds? So, we're recommending that people get a good doctor's letter that just outlines all this, but we don't know yet how we can tell you to submit it, especially if it's by telehealth. Where are these assessments done? The regulation says the nurse assessment will be done in the client's home, or if they're in the nursing home or hospital, but there is silence. There is nothing in the regs or the policies about where that practitioner assessment is done. I assume it's done in person or telehealth, but I don't know where. And we're concerned that people will be really pressured to use telehealth, and not everybody can use telehealth. But if they don't use telehealth, it might be very, very delayed. And at the end of this, here's an example of the notice. They're going to be confusing. Just going to run to some other things that I know you're concerned about. The reason why NIA might find someone not eligible is if they're medically not stable. And we're a little afraid that they're going to be ramping up those determinations. So be on the lookout for that. This is the standard from the regulation for that. Now this high need panel, once this is rolled out and it's used for existing people, say on a reassessment, people in MLTC, if they already have more than 24-hour care, they'll never have to be sent to this panel. This panel, the high need panel, the independent review panel, is only for people who have never received more than, or who are not now receiving more than 12 hours a day. So we're very worried about capacity. And here's an issue that we're alerting people about. People are used to requesting that conflict-free assessment and being able to do that while their Medicaid application is still pending at the Medicaid agency. And that's been true. The guidance on the conflict-free said, absolutely, that's possible. The new regulation says it should be possible because Medicaid eligibility must be established before services are authorized. So fine, that means you should be able to be assessed. But the new policy that just came out like 2 weeks ago says they'll only conduct these assessments for individuals with active Medicaid. And the ADM and all these sites are earlier in the PowerPoint is inconsistent. And one place says they can be processed concurrently, but another place it says you have to have active Medicaid. So I can't, I'm just alerting you that if you have your Medicaid application is still pending, you might get bounced back. And I think advocacy needs to be done on that point. There are also issues about fair hearings. So I didn't cover everything, but you know, I'll be around for some Q&A, and there's been a lot of advocacy done by NILAG and Medicaid Matters. You can look at some of the questions we've asked, which we have not received answers to. And very important numbers on the bottom of this slide. The MLTC complaint unit, if it's an MLTC case, there is a number and email for the conflict-free, that should be not conflict-free, independent assessor. Use those, report problems. They need to hear about them. All right, and then the rest is there for your information. Thank
Valerie,
you.
thank you so much. Nice round of applause.
Okay.
For our constant companion, Valerie Bogart. We could only give you a touch of the new rules today. We just don't have time. She could do 8 hours on these new rules trying to explain them. But 2 years ago, we didn't have such a caring economy, did we? Greg, you want to come on up? And there's an old saying, justice delayed is justice denied. Well, I think that applies to care. Care delayed is care denied. If you're discharging from a hospital and you need home health care, and you now have to get all of your eligibility done financially, then start the process of getting your independent assessment, then the physician assessment, then the MLTC assessment. We were 4 to 5 months to get Medicaid under the traditional program already. What's it going to be now? What's it going to be for the people that are applying now? And remember, the purpose of these rules was to cut $2.5 billion out of the Medicaid budget to reduce spending on Medicaid home care. And that's what we're looking at. Elimination of the person's own physician, to me, is the harshest of all of these new rules, because you don't get your own doctor to tell the government what your needs are. You have an independent virtual assessment by a physician. And they're taking the doctor out of the game, and they're trying to take the person's lawyer out of the game too, by reducing appeal rights. So we will be advocating throughout this process. We talked about it last year and the year before. There's going to be fair hearings. There's going to be litigation, court litigation. These new rules are going to spur a lot of controversy as we go through this process.